Mr. Murali, Pillai.
Mr. Deputy Speaker, sir, please allow me to declare my interest as a litigation lawyer in private practice. Given the bicentennial commemoration this year, I think it would be apt to pay tribute to the original framers of the Penal Code, which is one of the oldest pieces of legislation in Singapore, in the administration of criminal justice in Singapore. Professor Ho Peng Kee, then the Senior Minister of State of Home Affairs, colourfully described the Penal Code as, quote, the mother of all statutes, unquote, when it was last reviewed in this House in 2008. There are masterful commentaries about the history of the Penal Code in two textbooks. The first book is Criminal Law in Malaysia and Singapore by Professors Stanley Yeoh, Neil Morgan, and Chan Win Cheong. Incidentally, Professor Stanley Yeoh and Professor Chan volunteered as members of the Penal Code Review Committee. The second book is The Development of Singapore Law, Historical and Socio-Legal Perspectives by Professor Andrew Pang, as he then was. I relied on these commentaries in the preparation of my speech. The principal framer of the Penal Code was Lord Thomas Babington Macaulay. In 1837, the Law Commission, which he chaired, produced the draft of the Penal Code. For the draft, Lord Macaulay drew inspiration not just from English common law, but two other sources, the French Napoleonic Penal Code of 1791 and Livingston's Code for Louisiana, which was printed in 1833. He drew from the best ideas from continental Europe, America, and UK. Already then, it was not uncommon to trawl the world for the best ideas to be incorporated into draft legislation. Eventually, the Penal Code was introduced in India in 1860. A decade later, substantially the same copy of the Indian Penal Code, with its 511 sections, was enacted as law in Singapore through Ordinance 4 of 1871, when Singapore was part of the Straits Settlement. Since then, law students, lawyers, and our courts have referred to Indian case law when interpreting our Penal Code provisions. What were the main objectives of the Penal Code then? The principal objective was to codify common law, criminal offences, which is really judge-made law. And in the words of Professor Pang, quote, replace the manifold systems of criminal law then existing, unquote, with a single code. The Penal Code allowed lay people to understand what kind of action and behaviour amounts to criminal conduct, as well as the precise ingredients that make up these offences. Almost 150 years later, the Penal Code continues to play an important role in the administration of the criminal justice system. It clearly withstood the test of time. The Penal Code is applied every day in the state courts. Given the evolving nature of our society and our mores, the Penal Code had to be, and indeed was, revised from time to time to ensure its relevance. As mentioned earlier by the Honourable SPS, Mr. Amrin, the last revision of the Penal Code was done by this House a little over a decade ago in 2008. I reviewed the work of the Penal Code Review Committee, chaired by the Honourable Minister, Ms. Indrani Raja, and co-chaired by SPS Amrin. The PCRC members are all eminent people drawn from the judiciary, legal service, ministries, academia, and private practice. Together with their collective knowledge, experience, and wisdom, they are uniquely well placed to undertake the review. As we heard from SPS Amrin, they delivered a 500-page tome. I believe that this House owes the PCRC a debt of gratitude for executing the gargantuan task of updating the Penal Code so well. I also commend the Ministry of Home Affairs, just like what Professor Walter Teixeira said, for conducting extensive consultation with the public and VWOs before presenting this bill. A simple perusal of the bill will reveal the extraordinary breadth of the review that was undertaken. We see updates on the following areas: the extraterritorial criminal jurisdiction of the offences, concepts of fault and physical elements that usually make up an offence. These elements are the equivalent of the computer source codes of our criminal provisions. General defences that may be raised by accused persons, creation of new offences and enhancement of sentences to protect the vulnerable and minors and to deal with modern circumstances and advances in technology, updating of sentences to ensure their deterrent effect, and removing offences which are seen as anachronistic or irrelevant. The recommendations that the committee made took into account issues raised by our courts in many judgments. I'm reasonably assured that with these enhancements, the revised Penal Code, once passed, will continue to play an important role in the administration of criminal justice in Singapore. I would now like to make several observations and comments on the bill. First, I'm glad that the Honourable Minister, through a notice of amendment issued on 26 April 2019, accepted my suggestion made outside this House after the first reading of this bill to remove the thought crime provisions, namely Section 121A and Section 121B of the Penal Code. Presently, it is an offence to imagine the death or hurt or imprisonment or restraint of the President, and the accused, if convicted, may be sentenced to death or imprisonment for life. It is also an offence to imagine the deposition of the President from the sovereignty of Singapore. These are clearly anachronistic provisions. It simply does not sit well with the mores and values of present-day society. I'm not alone in making this call. The Honourable Member, Mr. Charles Chong, made this call in 2008 in this House. He said, and I quote, "It is of course right that anyone who plots, plans or actually takes action against the person or the office of the President ought to be punished. But merely imagining any of this, should this really be in our books?" It did not appear that Mr. Chong's question was answered then. Nonetheless, it has been answered now. Second, I note that the proposed Section 120A dealing with criminal conspiracy is significantly narrower. The proposed provision would have the effect of decriminalizing a conspiracy to commit an illegal act, which was defined as anything that furnishes ground for civil action. May I please ask, what's the rationale for this? How does the narrowing of the definition of criminal conspiracy reflect on the expected standards of behavior within our society? How does this square with the retention of the offence of criminal defamation under Section 500 of the Penal Code, which focuses on vindication of reputation? As members know, people who have been defamed also have a right of civil action too. I've also noted that potentially aggravated acts of defamation, such as threats imputing the unchastity of a woman under Section 506 of the Penal Code and insulting the modesty of a woman under Section 509 of the Penal Code, are proposed to be repealed. What then is the basis to continue to make defaming another a criminal matter in these circumstances? Third, I have misgivings, just like the Honourable Member Mr. Christopher D'Souza, on the proposal to abolish Section 309 of the Penal Code, which currently criminalizes an attempt to commit suicide. I appreciate the point made by SPS Amrin as well as the PCRC that persons who commit such offences should undergo treatment instead. I wish to point out, though, that Section 309 of the Penal Code, read with the Criminal Procedure Code, now allows the court to impose on persons convicted for the offence of attempting suicide mandatory treatment orders aimed at providing psychiatric treatment for such persons in lieu of the jail term provided in the Penal Code. This would therefore take care of the concern expressed by the PCRC. There's also a practical function. It allows the police to intervene by arresting and sequestering the person in a safe environment, for example, a padded cell, so as to stabilize his or her condition. I understand from SPS Amrin that it is proposed that the police be given powers to intervene. I seek a clarification on the basis and extent of these powers, as well as when it is expected for these police officers to be vested with such powers. Third, there's also a signalling effect to would-be offenders, and this is a point that was made by speakers before me too. Next point, I believe there is a basis to consider amalgamating penal code provisions which cover the same ground as provisions in specific pieces of legislation. This will allow for more uniform application of the law dealing with the same area. Also, in addition, reforms of this area can be done more quickly instead of waiting for the next review of the penal code. In this regard, I commend the move to transfer Chapter 20 offences dealing with offences relating to marriage to the Women's Charter. Similarly, the penal code provisions dealing with kidnapping could have been consolidated with the provisions in the Kidnapping Act. This would be an opportunity to deal with and remove an anomaly in sentencing. Kidnapping under the Kidnapping Act may be punishable by death. It is not the case in the penal code. Also, the corruption offences vis-à-vis public servants in the penal code could be merged with the Prevention of Corruption Act. I seldom hear of these provisions in the penal code being invoked nowadays. Again, the penal code punishment for corruption offences is lighter than the PCA equivalent. Notwithstanding my comments, I support the bill.